All right, I think we're going to get a bit of a contrarian view now from Gert Nel, Managing Partner of Gert Nel Incorporated Attorneys. Thank you very much. He's going to speak about the future of the South African personal injury law practice. Thanks very much, Gert.
Thank you very much, and thank you to everyone making time to listen to us today. My assignment is to give a perspective of what's to be expected of the personal injury attorney in the future. And I'm going to focus primarily on the road accident fund because that's the arena that we or us are dealing with. Having regard to where we are at the moment, unfortunately, information is very limited in terms of the new strategy of the road accident fund, but we do know that they intend to make the system more accessible, more streamlined, and cost effective. Now, in order to facilitate or initiate this process, the road accident fund opted not to renew the contracts of the panel attorneys. They decided to, or there is mention made, as Dania said, of mediation as a possible way to solve the problem of settling matters quickly. My concern is that in terms of costs and the administration around the whole mediation process and the fact that there's no legal binding power to mediation, I'm a bit concerned that that might not be the solution on the long term, because it might just be more expensive than we are currently seeing the road accident fund having to pay for litigation. There has been mention made of a special RAF tribunal that would be headed by a judge, so that might be a possibility to facilitate the earlier settlements of these matters. The Road Accident Fund obviously has also mentioned that they will or are going to try and settle matters within 120 days. Now, all of us in this field knows that 120 days is not a practical goal, but in terms of where the Road Accident Fund is going, having regard to the fact that they are busy setting up what we call or what would be regarded as a settlement hub. More or less what we saw with, in the 90s when the MMF, the predecessor of the RAF, was in place, you had claims handlers that were legally trained. Many of them were admitted attorneys. They all had mandates and they were all capable of settling matters. In those days, when you received the summons, you were called into your manager's office and you had to explain yourself. So litigation was limited to the very few matters that were very complicated and could not be resolved otherwise. So I foresee that that is the route that the Road Accident Fund is taking, and I would presume that the block settlement route will preempt anything else, be it mediation, a tribunal, or having to go to court eventually to try and settle a matter. And I think the view of the Road Accident Fund, or the approach would be, is to compile a panel of exceptionally qualified people to attend to this block settlement hub, because the efficiency of that hub would depend on people that can go toe-to-toe with well-seasoned plaintiff attorneys. And in order to achieve the goal of settling matters earlier, Dani mentioned the fact that we can reasonably expect to settle matters at least 2 years earlier than we are currently seeing. So that would entail a total rethink of the way that you practice, because to a large extent litigation would be a thing of the past, and with things as they are at court at the moment, I think that's a blessing, because I think we're all aware of the complications and the additional strain that we have to take as a result of practice directives that are just impractical, and that's making the access to courts of our clients very difficult at the moment. So I'm very positive about what's happening, and the fact that the fund is extending a hand to plaintiff attorneys to engage them directly. I must say, before lockdown, when the first news broke of a new strategy by the Road Accident Fund, and then complete silence, had us all worried about what was going to happen post lockdown to our clients. And I must say, I was quite surprised and to see that the Road Accident Fund actually stepped up to the plate, and they are settling matters. The previous term, our firm and from what I've heard, other firms did quite well, and even in this term, the Road Accident Fund is really coming to the party, and having regard to the limited resources that they've got, I think they're actually doing a sterling job in settling matters and making sure that traction is kept. And at the moment, they are attending primarily to matters that are on the trial roll. So, but you know, if that backlog has been worked out, obviously this settlement hub of them, I think, would be the answer. So I think, you know, in short, if the Road Accident Fund strategy works, it's a win-win situation to us all, because we will settle claims earlier, the RAF will settle or manage to save costs, and we as plaintiff attorneys will be able to remain in the arena, because the alternative, as Peter has alluded to earlier, is the benefit scheme. And under the benefit scheme, there's no future for attorneys. So we need to work together with the fund, assist as far as possible. We might not be able to settle claims in 120 days, but I think we can make an effort to and use it as a goal to compile and rather prepare claims more diligently prior to filing or lodging the claims with the RAF than having to depend on litigation to connect the dots and putting unnecessary strain on the Road Accident Fund.
Thank you very much for that, Gert. We don't have much time left, so I'm just going to throw a question out there. Would any of the panelists who's able to answer this please try to give us a succinct answer to this? One of our anonymous attendees says, what would be the best advice for medical experts owed by attorneys? How can we recoup our money? Which of you would be able to answer that, panelists?
Joanne, Jan de Beer here. If I can maybe respond on that specifically. In that, the agreement between the medical expert and the attorney is probably going to inform exactly what that recourse could be. Because you do find that in certain instances, even those experts are also at risk pending the outcome of the matter as well. And that's a risk that medical expert or any other expert needs to consider as they engage and provide those services with the attorney. And of course, in that, there's proper civil recourse against those that legal practitioner in the event that, depending on that agreement, of course, whether those monies can be recovered or not. On that, it's also important to note that specifically from the fund side, as we look at our own practitioner risk management framework, that type of conduct of non-payment by a legal practitioners for the service that has been provided probably points to other risks and concerns that the fund might have in respect of what's happening within that legal practice. And it could also point not just in terms of risk to that medical expert and the monies that is owed to them, but also to the client, which of course is who they're representing and where we then have an interest. We find in numerous instances from a risk point of view that if these accounts are not settled, if they're not honored, if those agreements are not adhered to, it talks about a significantly increased risk in that specific legal practice, which warrants further attention and consideration by the fund side to try and minimize its own risk and of course protect those clients as well. But in that as well, it's important that in this environment, from a conduct point of view, even the regulator, being the Legal Practice Council, should have an interest in those things as well. But again, I don't want everybody now to go and rush out and go and report a lot of these practitioners in that regard, but have regard for your own agreements that you have. And if you warrant, or do you feel that there is proper recourse in that it should be pursued. And if need be, because of the conduct of that legal practitioners, and if it warrants reporting to the regulator, then that should take place. Because you don't want to find yourself in a situation whereby you've got a certain component, even though it's a very small component of practitioners, through their conduct negatively impacting the overall industry and make it unbearable for the majority of these legal practitioners that do provide excellent services and also supports their clients in a great way. So this type of conduct is not acceptable. In my view, from a risk management point of view, does reflect on other concerns that we might have in respect of that specific firm or the conduct of that legal practitioners. And it's we've got a duty to make sure that we address that.
All right.
As we look at that specific service provider and as we look at the clients, those are the people that forms important components in this overall chain of value that is being created, and we cannot allow that to fail. So that's my view on that. Thank you.
Thank you so much for that, Jan. Donnie, you wanted to comment on that?
From the defendant side, the Road Accident Fund have panels of experts, and they have service provider numbers that are allocated to experts, and all of those experts are paid directly by the fund. The only experts that are paid via the defendant or ex-panels officers would be those who do not have a service provider number or who are not on a panel that has been appointed or approved by the RAF. And the defendant attorney is never a principal in that relationship. We act only, or we used to act, as an agent on behalf of the RAF, and the contract for the rendering of services is between the expert and the fund, not the attorney. So the defendant panelists attracts no liability as far as experts' accounts are concerned, in respect of those which are not paid directly by the fund.
Thank you for that, Dani. I'm going to take one last question simply because we've run out of time, but don't be discouraged because the rest of your questions are being made a note of and they'll be answered offline. One of you has asked, what is the current status of RABs? Who exactly can comment on that for us, please?
Perhaps I should deal with that. 3 comments quickly. In December 2018, the RABs bill was defeated in Parliament for a second reading. Therefore, it was put on an auxiliary list in the 5th Parliament. 2, although there are utterances in the press, it is still alive and kicking and still remain a risk, despite what people think. Thirdly, it's on the Portfolio Committee of Transport's agenda on the 21st of August, and who knows what may be the further outcome. We are, from an APRA point of view, keeping a key eye on that, but that's the factual position.
Thank you very much for that, Peter. So I want to thank you all for joining us today. It's really been a pleasure being with you. And one of you watching did actually ask about this, but a copy of the webinar and any presentations that are shared will be emailed out in the next few days. So you can look out for that, particularly if you haven't been able to watch the entire webinar. I'd like to thank Taurus for making this possible and say a special thank you to all the panelists who've made themselves available for this discussion today. And thank you for your insight into what is quite a vast issue to look at. And it's going to take quite a long time to unpack. So I hope we're going to have more of these discussions. If you'd like to go to the Taurus website, you can go to tauruscapital.co.za, especially if you're in need of funding for your law firm. Now, when you leave the webinar, you will also be directed to a brief survey link, and we'd be hugely grateful if you would complete that, please. Thank you so much for being a part of this discussion today. Take care.